Milwaukee, 1972. George Carlin is dragged off stage by police for saying 7 words. It seemed like a local joke at first. But 6 years later, those same words reached the highest court in the land and lost him into history. The resulting case, FCC versus Pacifica, didn't just lose George Carlin into history. It created the legal borders that still govern every radio and television broadcast in America today. This is GC 5000. To understand how a comedian became a constitutional landmark, we have to go back to a country at war with its own language. The early 70s were a time of profound cultural fracture. The establishment was reeling from the 60s, and language was the front line. Traditional values were clashing with a new, raw honesty that didn't care for euphemisms or polite society. George Carlin had spent the 60s as a clean-cut suit comic. He was the funny guy on variety shows, making safe jokes for a polite audience. But internally, something was changing. He was tired of the artifice. He saw the hypocrisy of a society that could tolerate the violence of war on the evening news, but could not handle a few 4-letter words in a joke. As the decade turned, he found his real voice, a cynical, brilliant observer of the taboos we hide behind. He let his hair grow, put on denim, and started talking about the things you weren't supposed to mention. He moved from the variety show stages to the coffee houses and college campuses. He wasn't just telling jokes anymore, he was performing linguistic autopsies on the American psyche. Carlin was walking a path paved by Lenny Bruce, the comic who had been hounded to death by obscenity trials in the 60s. Bruce proved that words could be dangerous. Carlin wanted to know why. Bruce's legal battles had mostly centered on obscenity, a prurient interest in sex. But Carlin's target was indecency, the simple, everyday words that were banned for no logical reason. The routine 7 words you can never say on television was more than a joke. It was a linguistic dissection of the words that kept polite society up at night. He began listing them. It was a linguistic dissection. He wasn't using the words to be vulgar. He was using them to show how their power was entirely manufactured by our own fear of them. July 21st, 1972. Summerfest in Milwaukee. Carlin takes the stage as the opening act for Arlo Guthrie. 10,000 people are in the audience. The energy is electric. At 10 p.m., he drops the heavy 7: shit, piss, fuck, cunt, cocksucker, motherfucker, and tits. The audience is laughing. The festival security is unbothered. But Elmer Lenz, a police officer attending as a private citizen, is at the carnival midway with his wife and child. He hears the routine over the loudspeakers, and he is incensed. The festival's acoustics meant that Carlin's amplified voice carried across the cotton candy stands and rides, reaching the ears of a family that hadn't paid for the show. Lenz tries to arrest Carlin mid-set. Security holds him back to avoid a riot. They wait. They wait for the final bow. As Carlin exits the stage, the police move in. Carlin is taken into custody. In the frantic minutes before the booking, his manager reportedly clears his pockets of anything else that might complicate the charges. He's booked for disorderly conduct and violating obscenity laws. He spends the night in a cell, releasing the next morning on $150 bail. The Milwaukee 7 are born. In December 1972, the case reaches Milwaukee County Judge John Schultz. The prosecution calls a local schoolteacher as a witness, who testifies that the language was offensive and vulgar. But Judge Schultz dismisses the charges. He rules that while the words are indecent, they didn't cause a public disturbance. Carlin's performance was satire, not a breach of the peace. The victory in Milwaukee was sweet, but the battle for the stage was just the warm-up. The real fight was about to move to the public airwaves, the one place the government claimed to own. The Pacifica Foundation was founded in 1949 with a radical mission: anti-censorship and pluralism. They were the listener's radio, funded by the community, not corporations. By the early 70s, Pacifica stations like WBAI in New York were hubs for avant-garde art and activism. For them, Carlin's routine was a perfect example of essential social critique. October 30th, 1973, WBAI-FM in New York. A program called Lunch Pail airs Carlin's filthy words monologue. The host even gives a clear disclaimer before the track plays. The program was a deep dive into contemporary attitudes toward language. The monologue was intended to deconstruct the taboos, not just to shock, but shock it did. John Douglas, a CBS executive, is driving with his 15-year-old son. He tunes into WBAI and hears the monologue. He is appalled that garbage is airing in the early afternoon. Douglas files a formal complaint with the FCC. He argues that no child should be subjected to such content in the middle of the afternoon. He becomes the catalyst for the commission. In 1973, the FCC is led by Chairman Dean Birch. Under his leadership, the commission is taking an aggressive stance against indecency and drug-related content on the airwaves. Birch sees Douglas's complaint as the perfect vehicle to set a precedent. The FCC issues a declaratory order against Pacifica, placing a permanent reprimand in their file. Pacifica Foundation refuses to back down. They see the FCC's order as a direct violation of Section 326 of the Communications Act, which explicitly prohibits government censorship. They argue that the government cannot act as a national nanny. They maintain that Carlin's social satire is as protected as the works of Mark Twain or Shakespeare. In 1977, the U.S. Court of Appeals for the D.C. Circuit rules in favor of Pacifica. The decision calls the FCC's order vague and overbroad. It's a huge victory for free speech. Judge David Bazelon's majority opinion is scathing. He argues that the FCC is attempting to sanitize the airwaves in a way that violates the very essence of the First Amendment. Bazelon writes that the government has no business deciding what is decent for the entire American public. But the FCC isn't finished. They appeal to the Supreme Court. April 1978. The case reaches the marble chambers of the Supreme Court. The question is no longer just about Carlin. It's about the very nature of broadcast regulation. The oral arguments are rigorous. The justices grapple with the distinction between obscene and indecent. The FCC argues that broadcasting is a unique and pervasive medium. Solicitor General Wade McCree argues that broadcast enters the privacy of the home unbidden, making it fundamentally different from a book or a movie theater. Justice John Paul Stevens writes the majority opinion. He uses a famous analogy. A nuisance may be merely a right thing in the wrong place, like a pig in the parlor instead of the barnyard. The pig is the indecent speech, the parlor is the home. Stevens argues that the government has a compelling interest in shielding children from such content. In a razor-thin 5-4 decision, the court upholds the FCC's power. They establish that broadcast media has less First Amendment protection than any other medium in America. This ruling codifies the safe harbor concept, restricting indecent content to the hours when children are presumed to be asleep. The precedent is set, and it's permanent. Justice William Brennan issues a blistering dissent. He accuses the majority of ethnocentric myopia, arguing that they are sanitizing the airwaves to suit middle-class sensibilities. Brennan famously argues that the listener is protected by the flick of a switch. If you are offended, you turn it off. The government, he says, has no right to do it for you. He warns that the ruling reduces the entire adult population to hearing only what is fit for a child. He calls it a patent misapplication of the First Amendment that will chill creativity. George Carlin wasn't a party to the case, but his words were the heart of it. He was energized by the ruling. He saw it as the ultimate validation of his linguistic philosophy. He later said he took great pride in knowing his filthy words were now part of a Supreme Court decision. He often joked he was the only person explicitly censored by the highest court. The Pacifica ruling created the safe harbor era. For decades, it dictated what could be heard between 6 a.m. and 10 p.m. It became the legal bedrock of the broadcast industry. Every network, every radio station had to abide by these rules. The safe harbor was the only time the 7 words could emerge from the shadows of the airwaves. In the early 2000s, the Pacifica doctrine was tested again by fleeting expletives. Unscripted slips from celebrities like Bono and Cher on live television award shows. The FCC toughened its stance, issuing massive fines for single words. The network sued, leading to another long legal battle that eventually reached the Supreme Court in 2012. The crackdown was catalyzed by the 2004 Super Bowl wardrobe malfunction. Though it was visual, the political firestorm gave the FCC the capital to broaden its enforcement. Fines for indecency increased tenfold, and delay buttons became standard for all live broadcasts. The 7 words case was being used as a weapon in a new culture war. In 2012, the Supreme Court ruled the FCC's fleeting expletive policy was unconstitutionally vague. The networks weren't given fair notice, but the court refused to overturn Pacifica. The Pacifica precedent remained intact for broadcast, but the landscape was changing. The rise of cable and streaming rendered the pervasiveness argument largely obsolete. Today, the legal divide is sharp. Cable and streaming services operate outside these rules because you invite them into your home. The medium you choose determines your protection. In a world where any word is a smartphone click away, the broadcast exception feels like a relic of a different era. Yet, it remains the law of the land for terrestrial radio and TV. Carlin's final lesson was about the power of language. He believed it was the last free country, the place where thoughts are born and articulated without the government's permission. He proved that even if they could restrict the airwaves, they could never restrict the mind. The 7 words case stands as a monument to the eternal tension between authority and truth. Was the court right in 1978? Or did they just move the pig from the parlor to the digital barnyard? Argue it like Carlin would in the comments below. If you want more untold stories of the legends who shaped our culture, hit subscribe to George Carlin, The Untold Stories. I'm Brian, and this is GC 5000. Thanks for watching this deep dive into the words that changed broadcast history forever. Stay honest, stay cynical, and I'll see you in the next one.